Peacock. It gives me immense pleasure to introduce Professor Peacock, who happens to serve as the president of the World Society of Victimology and chair of the Department of Criminology at the University of Free State, South Africa. Since the apartheid years in South Africa, he has been working actively in the field of victimology with child justice and institutional victimization as particular and focuses on these areas. He has served under several ministerial appointments and has also been a commentator for a prime-time crime and victimization television documentary series. As a National Research Foundation NRF-rated scientist, he has been playing an active role within the scientific community with the presentation of research findings at various regional and international symposiums. Professor Peacock has authored several scientific publications in English, Spanish, and other languages and serves regularly on scientific committees of international and local conferences as an editorial board member of international scientific journals. Thank you, Professor Peacock, for taking out your time. We look forward to hearing more from you. May I now introduce Professor Dr. Arvind Tiwari. Professor Arvind Tiwari is presently serving as the Dean, School of Law and Chairperson, Center for Police Studies and Public Security at the Tata Institute of Social Sciences, Mumbai. Before joining TIS in 1999, he also worked at LNJ, National Institute of Criminology and Forensic Sciences, Ministry of Home Affairs, Government of India, and National Human Rights Commission, New Delhi. For his industrious work in the field of criminal justice, forensic sciences, human rights, victimology, and youth justice, Professor Tiwari has been felicitated with numerous awards, including the prestigious Kumarappa Reckless Award, Dr. B.S. Hekewal, and Professor Sushil Chandra Award, and the Human Rights Millennium and Human Rights Promotion Award. Thank you, Professor Tiwari. Let me give you a warm welcome on behalf of the RGNUL community. May I now take the privilege of extending a vote of welcome to Professor Dr. M. Srinivasan. Professor Srinivasan is currently working as a professor and head of the Department of the Criminology, University of Madras, Tamil Nadu. Equipped with more than 25 years of professional experience, he has authored several monographs, editorials, and peer-reviewed articles on issues relating to victimology, criminology, juvenile justice, and economic crimes. In recognition of his contribution to this field, he has also been appointed as an honorary position of Vice President of the Indian Society of Victimology. Thank you, Professor Srinivasan. We, and along with the entire student community, we look forward to hearing more from you. Last but not the least, may I also take an honor and a privilege in introducing our beloved Honorable Mr. Justice Midha. It's been an honor appearing before him, before the Delhi High Court, and it gives me immense pleasure to invite him and introduce him. Justice J.R. Midha served as the judge of the Honorable High Court of Delhi from 11th April 2008 to 7th July 2021. As a judge, he presided over several jurisdictions, including judge in charge of the original side of Delhi High Court. He has headed a division bench hearing criminal appeals involving life and death sentence references. He has also served as the chairperson of the Delhi International Arbitration Center, chairperson of Delhi, chairperson of Judicial Education and Training Program Committee of High Court of Delhi, member of the subcommittee of Supreme Court on the use of artificial intelligence in MACT cases, and many other advisory boards and committees. As a judge, Justice Midha had actively initiated judicial reforms in various jurisdictions, namely arbitration, motor accident claims, execution cases, maintenance in matrimonial cases, compensation of victims of crime, prosecution for false claims, prosecution of proclaimed offenders, and lastly, Justice Midha had recently authored several landmark judgments on victims and restorative justice, where I am very proud to say that our very beloved Professor G.S. Bajpai had assisted the Honorable Court in reaching factual and legal findings, and which we all of us look forward to hear more from Justice Midha. Now, having briefed our audience about our expert panelists, in as much they did not need much of an introduction, today's theme and topic revolves around a very, very pertinent issue, which again, at least in the global south, in the context of criminology, is a miss. That is victims of crime. We have a very robust administration of criminal justice system where we take pride in talking about or addressing issues pertaining to restitution, reformation and other aspects, but victims hardly ever say when it comes to administration of justice, their participation is lagging behind. We believe that the judgment which was recently pronounced by the Honorable High Court of Delhi had highlighted the role of victim impact statements to a larger extent. Yet the role of victim participation remains mostly symbolic. Therefore, this session, which is pertaining to marginalization and the access to justice in the context of victimization, is of much more relevance than ever. Let me therefore begin by requesting Professor Robert Peacock, if Professor Peacock could elaborate and initiate this discussion on marginalization and access to justice from a victim's perspective, and perhaps also elaborate on the role of victim in global south, at least in terms of administration of criminal justice, as it requires a much more deliberate consideration. Over to you, Professor Peacock.
Thank you so much. Good afternoon to everybody, and once again, thank you to the Vice Chancellor, Professor Bashpai, and our distinguished guests being here again today. I think this is just such a wonderful platform, and in particular, as that was just mentioned now, the commonalities and the differentiations we are experiencing as from the global south, particularly between Africa and India. And this, of course, would also be of value towards South America. So, yes, so when we are talking about the concept of marginalization, I think it would be pretty fair to say, and research actually supports this, that all victims are basically can be considered a marginalized group within the criminal justice system. But sadly so that there are some other groupings which are even more marginalized than what we see or tend to see as sort of the general mainstream victim. So, but my presentation today, my few minutes of introduction from the African continent, will focus on marginalization in more than one way. The first would be the impact, and we share this legacy, the impact of colonization on traditional knowledge systems and how this has affected our criminal justice system, as well as victim empowerment and marginalization as a previous colony. That is the one dimension. And the other one is the whole concern of us in the global south, in terms of agenda setting, in terms of especially theory development. I think that is really an important factor that we need to visit. And there is sort of quite a chorus of support that actually shows how marginalized the global south is from the sort of more mainstream North American, European traditions in theory. So which of course also have an impact on research and on practice as well. And then just lastly, I know there's not too much time and there's going to be a wonderful opportunity for discussions, just to look at the status quo of the victim and the marginalization of the victim as within the global south and global north. Now, I think it's fair, if one starts looking at the beginning of marginalization, that it would be quite fair to also look at how victims were seen at and came to the party within the traditional Western tradition. Professor Gerd Kirchhoff, I think which many of you are familiar with, he highlighted that within the context of European cultures, usually the Mesopotamian route is followed as the most significant reference point. And he was able to establish and research from a Western viewpoint that the ancient code of Ur-Nammu, and this was about 2100 BC, before Christ, prescribed in addition the imposition of the death penalty restitution to be paid by the offender and to the victim. Now, so often, you know, we are sort of confronted and we are engaging, and there has been a lot of privilege in terms of knowledge systems, and a lot of traditional knowledge has been corroded within the African context, and I think definitely elsewhere in the global south as well, due to the importation of Western constructs of victimization, of criminal justice, and of the law. Now, we tend to follow the lead in terms of these mainstream orientations, but interestingly, just getting back to Professor Kirchhoff's observations, if we look in Africa, what we do is we would trace usually our history right back to the Egyptians. Many years before 2001 before Christ, in fact 2400 before Christ, there has been a manifestation or a tradition in spiritual and in cultural beliefs in a Egyptian goddess of justice, who actually embodied the principles of restorative justice as we know it, and which has also sort of culminated into Ubuntu, the African humanist values of Nelson Mandela and Desmond Tutu and others. Now, so long before the Western discovery of the victim, we already celebrated in Africa the traditional values of restorative justice, which is in essence a matter of equilibrium, it's a matter of harmony, it's a matter of balance, it's a matter of reciprocity and order. And this, of course, reminds you of restorative justice, which ironically at the moment is sort of used to modernize criminal justice, because it is at breaking point within the Western world. A lot of investment with very poor results indeed. Now, so yeah, from your rich history, or the little bit I know of, I think you have got enormous wealth of traditional knowledge systems, and that can be explored likewise, which we did in South Africa, because we use these Ubuntu values, these Egyptian values of harmony and balance, in order to facilitate a transition from autocratic rule and autocratic regime to that of democracy. So through our Truth and Reconciliation Commission, criminal justice would simply not work, not just because of the numbers, but it has lost complete credibility amongst the majority of the population, because it was used in service of apartheid rather than crime prevention. So I think it's going to be very interesting to hear more about your indigenous own experiences.
I'm so sorry to interrupt, Professor Peacock. Only building on this, because it's a very pertinent issue. So far as wealth of traditional knowledge is concerned, I've read a book by Dr. Patrick Glenn on legal traditions of the world, where he talks about all the legal traditions continuously interacting. But how do we adopt this traditional knowledge system and implement it in the modern rule of law? Could you please elaborate on this aspect? Because that is where I believe a disconnect exists.
Yes, I think it would be arrogant of me to tell you how to do it in India, but how I would suggest the way we work with it is that what's important is the recentering of the indigenous voice. And this refers to epistemological orientations of the self. So when we engage with our policy formulation, when we engage with our theory development, with our research, that we make sure that the local voice is centered, or rather recentered. And this would refer to aspects of how does the local person view him or herself in relation to the world? Is it a collective orientation, or is it an individual orientation in terms of the more Western tradition? So that ontological question is very important, I think, if we want to incorporate it. So next would be some epistemological issues. Here we are looking at the type of questions we are asking. You know, rather than just simply labeling something as criminal behavior, we need to look at the underlying causes that actually create conflict. And I think that would be more useful. So we need a broader orientation from the traditional or the Western, rather, legal culture. But what I'm advocating, and it has worked very well in South Africa, would be the notion of judicial pluralism, so that we are decolonizing justice, but that we do not sort of discard the canons of knowledge, the value that other cultures can bring as well. But to answer your question, that we do this in a comparative fashion, and that we also integrate around our own cultural center to make meaning of the world around us. And I think that has worked very well, because in our context in South Africa, which serves as an example for truth commissions worldwide, is that we've used this culture of humaneness as the vehicle to transition from an autocratic regime to reconciliation. But of course, you know, in terms of models, in terms of law itself, there's always the situation and the challenges around context. So in terms of, I'm in favor of a pluralistic orientation, but that we sort of just recenter the local voice, the indigenous voice. I hope that answered your question.
Perfect. Thank you. Thank you, Professor Peacock. That was really insightful. I'm sure that some of our participants and audiences would want to get back to some of these issues which had been aptly raised by you. May I now invite Professor Arvind Tiwari to the podium to kindly share his views on the topic. Thank you. Over to you, Professor Tiwari.
Yeah. Thank you, Advocate Sanjay and my esteemed panelists. And at the outset, I would like to thank RGNLU and Professor Bajpayee and his team, organizing team, for inviting me. And I really appreciate the efforts made by organizing team, sending us several reminders and all updates on time. So thank you very much to the organizing team. Now, I have been given by the organizing team 5 areas. In briefly, I have, Sanjay ji, how much time? Around 10 minutes?
Please, sir, 10 minutes.
Yeah, because we have to avoid the timing also. So, like 4 or 5 areas which have been indicated by the team. One is the systematic problems faced by marginalized and vulnerable victims in gaining access to criminal justice system. Now, if you'll see who are the vulnerable groups, the women, scheduled caste, scheduled tribe, children, senior citizen, disabled people, who are migrants, people living with HIV/AIDS, sexual minorities, etc. These are the people, those who are the marginalized otherwise, and also in gaining access to justice through the criminal justice process is a serious problem for them. For example, as we all know, that social justice versus criminal justice, if we will see, so the social exclusion is a serious problem. So that is also reflecting in the response of the criminal justice to the vulnerable groups, the victims from vulnerable groups. For example, like if you'll see the registration of crime or access to file FIR and to get a free copy of FIR. This is still a problem, although there are several judgments and there is the provision in the law. But despite that, registration of FIR is a Herculean task. And that the victims' right to fair investigation and fair trial. And sometime I would like to just place very humbly to the gathering that sometime even the advocates or the human rights activists and some academicians also they say, are we talking victims' right at the cost of the accused rights? And perhaps no. We are saying that we want, if we are saying fair trial, fair justice, fair investigation, then the victims' rights should also be taken care of along with the accused rights. So that has to be seen, victims' rights vis-a-vis the accused rights in terms of fair investigation and fair trial. Then victims' right to participate in court process, legal aid, we all know, legal aid in somewhere it is provided properly, but in many places the legal aid is not, the status of legal aid is not so encouraging to the victims. And then victim protection and schemes, if we'll see, like although schemes are there, but the implementation the several questions are there. Then victims' rights in sentencing process, whether how the prosecutors are they taking into consideration, or the victims are being heard by the court before deciding the sentencing process. So that is also, although there are some kind of, you see, framework, there is a framework, but still we have to travel a long journey. Victims' right to appeal. So, and right to restitution and compensation. We have 357A and several other laws are also having the provisions for the victims' rights to compensation. Now, the Criminal Law Amendment Act 2013 and 18. We all know after Nirvaya case and Justice Verma Committee report, several legal provisions have been made. But there is still a need that we hear the incidences in the media and social media and print media, electronic media, that still the crimes are not being registered and the victims are not being treated well. So this is the broad kind of areas. If you will come that what is the provision of like positive obligation on the state. State, there is a robust provision in the constitution. Then various act also have provision for various kind of positive steps for the victims of crime, like Provision of Offenders Act has the provision. Then the Protection of Women from Domestic Violence Act, then Scheduled Caste and Scheduled Tribe Prevention of Atrocities Act has the provision for the victim compensation at different stages. Then protection of women from domestic violence and sexual harassment of workplace. So there are several laws also and provision, particularly POCSO has several provisions. Now the question is that these kind of provisions which are there, whether these are being properly reaching to the victims of crime. We all know in the colonial criminal justice system, still we have the colonial mindset of several functionaries of criminal justice system, and the police and criminal justice accessibility to the poor people and marginalized people is still not reach out up to the ground level. Things are being done and several steps are being taken, but there is a need. For example, like compensation. If we'll see the compensation, still the judiciary, particularly the district level judiciary, that is not so open. There are some studies, there is no time, so I will not go to that. So there is a need that, that there is a need that all these system, training institutes and the senior people from the system, and there is a need to give the training and change of mindset, that the victim oriented kind of justice, because that is also, if we are saying fair justice, this also includes. Several schemes are also initiated by the government for the victim support, like emergency victim support.
But Professor Tiwari, if I may just
Yeah.
interrupt and ask you a question.
Yeah.
For instance, I've been a party to such cases where there has been a vulnerable child victim in a POCSO matter, for instance.
Yeah. Yeah.
And the procedural requirement or the procedure to claim that compensation is very, very cumbersome, and it requires a lot of patience and, in fact, assistance of a pleader or an educated person.
Yes.
How as an academician do you feel about this procedure being so cumbersome?
Right. You are right, because the procedural handicapped or roadblocks, if I'll say, are very much not only in POCSO but in entire access to justice exercise fields, starting from the police, for example. Like how to, it is not the you see, understanding of right. I always say, it is, even suppose I am a poor victim, crime victim. If I want to go to register my crime and I know this is my right, this is my right to get a free copy of the FIR without paying anything. Despite that, my bargaining power is not there, and being colonial mindset there at the police station, although reformation is happening, transformation is happening. So what I'll say, that there is a need to rework and transform our procedures, and because these should be even law, I will say, like law is also so difficult to understand for the educated people, even the language of law in general, or the judgments. So we need to also rework on these issues, that the entire process, so that in a very simple language, in a local language that can be translated, and also the other kind of institution like panchayati raj institutions, asha workers, and other kind of the health workers at the local level, and Nyam, so we need to reach out to the people, particularly at different layers, so that the confidence can be generated amongst the victims of crime, that system is for us, and also the redressal mechanism should be there. Because if suppose at the focal point they are not being attended, then what is the way out? If there is a board in the, for example, like custodial violence, we know, like Joginder Singh and all those guidelines are there, arrest, regarding arrest, when we say. But when we are seeing it actually implemented, the implementation creates a problem, because if the local police station is not listening, where to go? Whether the senior officer is available, access to judiciary is not so, also so not easy for the poor people. People say they can go to the magistrate. How to go? If I am a poor victim, I have hardly a few pennies in my pocket. How can I access the court? And pro bono lawyering. So as you have rightly said, that the procedure, as well also the accessibility in terms of like the more proactive role of the legal services authorities, the law colleges, the law graduates, and not only law graduates, rather I say that graduates from the universities, simple universities, because this is the basic kind of documents are prepared, and these are being distributed, and college graduates and other are also encouraged. And even at village level, the 10th pass, 12th pass people are being familiarized with this, and social media can be used nowadays. Even the youngsters are very, very fond of social media. So perhaps we have to find out these ways and means, and the academicians, like not only to conduct the research studies, we have to do the evaluation studies, along with we have to disseminate in such a manner to the different stakeholders, uh, that those are reaching in a simplified manner, so that that could be, so we all have to bring together and break our heads together, like that translational criminology. Now that says that we have to come together, that the practitioners, criminal justice practitioners, and the researchers, and we have to come together and bring out. So victim perspective, if we are saying in terms of, for example, like victims' rights movements, or we can say role of community in victims, protection of victims' rights. Now we have several kind of movements, particularly like feminist movements, those who are fighting for the women's rights, then child rights, then rights against scheduled castes and scheduled tribes. For them also, they are people are fighting to get their rights. So there is a need that the academicians and the practitioners should come together, simplify the rules in a local kind of language that can be translated, and we have to, access to justice is still, although it's a legal right, fundamental right, but still access to justice is not so accessible, because the entire justice delivery process and the entire you see framework of the justice reaching to the community is still, we have to travel a lot, and perhaps there is a need that this should be made the mass movement kind of thing. And the legal services authorities, not only legal services but community, for example, like the sexual offenses, the victims, if asha workers and the local workers are trained, how to protect the scene of crime, how to preserve the physical evidences or the forensic evidences there till the police reaches there. So that
Professor Tiwari, so sorry to intervene again, but I can't help but to seek your views on primary, secondary, and tertiary victimization, because mostly our focus is limited to primary victimization of crime.
yeah,
Whereas the secondary or the tertiary victims, such as the family, immediate family, or the community at large, are again ignored or hardly made to participate.
yes.
What do you think in terms of your opinion?
You know, if we'll see secondary and tertiary victimization, like particularly the victimization at the family level, if you'll see domestic violence and other kind of aspects, you know that, as I said in the beginning, the social justice and the patriarchal approach, like if you'll see the patriarchal structure of the society, so some kind of victimization is also approved and also you see by the social kind of norms and systems, right? If you'll see the domestic violence, if we'll see the you see honor killings and all these kind of aspects, these are the social kind of issues which cannot be prevented, because the like sexual offenses, if we'll see the first victimization like primary is there, but the family itself in many cases they are also condemning the victim and no support is given to the victims of such crime, sexual offenses. So there is also need that we have to work, what I feel, at 2 3 levels. One, at the law, legal reform, and lot of like during last 30 years, lot of progress has been made through the progressive judicial pronouncements, the legislative measures, and the enactment of the several laws and the provisions for the victims and victim compensation, as well as victim impact statement and other things. But also at the same time, we have to work with the social justice and the patriarchal kind of mindset, and we have to challenge the socio-economic, cultural, and religious malpractices which are victimizing further the various people and various segments of people, including, if you'll say, sexual minorities, if you'll see the women and the children, scheduled caste, the caste atrocities kind of cases. So there is a need to deepen the social justice and also to work, because many times like so a movement, if you see victims rights movements in our country, although since last 30 years Indian Society of Victimology, several criminology department, law universities, now I could see a lot of changes in all these kind of support services and how to address the victimization at the tertiary and the secondary level. Things are being done, but I think there is a need to have concerted efforts and collaborative efforts, and we have to synergize the social justice, social reform, social transformation, as well as also we have to work with the communities. Many times, like political establishment, we academicians we leave the political establishment, or human rights activists generally they don't touch the political establishment. Yes, I think that there is a need that political establishment also several times the violations are happening, and we need to and the will which have to be created, political will to transform the social evils as well as the legal kind of framework. We need to get support from the political establishment. So there is a need to work in concerted manner, and social justice, you see, transformation of social justice and social inclusion process should be deepened, and also fraternity, as has been emphasized in the constitution, will come only through when we are also protecting the victims' rights at all levels, not only the legal is the main, because law is the protector of the rights, but along with the law, if the parallelly we are not doing the social justice and other kind of efforts, then tertiary and secondary victimization will continue. So perhaps that is
Thank you, Professor Tiwari. I mean, this could perhaps continue for the rest of the day, but I must now take this opportunity to invite Professor Srinivasan with his expert comments and to take the discourse on victimization forward. Over to you, Professor Srinivasan.
Thank you very much. Before I commence my comments, I'd like to convey my warm greetings from the University of Madras to all the participants. And I sincerely thank all the organizers, particularly Professor Bajpai, Vice Chancellor of Law University, And just two things. I would like to, because it's an academic exercise, I would like to start with clarifying or defining the concept of marginalization. Then that I would like to spend a couple of minutes. And thereafter, I would like to demonstrate how marginalization becomes a major factor as a cause for certain unique forms of victimization. Then it comes how marginalization again is a major factor, hurdle for them while accessing the justice. So therefore, I would like to start. I think I would draw your attention to understand the concept of marginalization. Several authors, several scholars across the globe, they have been trying, including now we have listened to Professor Peacock, and he also started with defining the concept of marginalization. Because it's very, not a very complex concept, but not well defined. For instance, a professor from the University of Strathclyde, Scotland, he attempted to define marginalization, and he said like it is a global problem which impacts negatively upon societies across the world. He says like the concept of marginalization permeates the current literature but is rarely defined. It is usually a relation to the concept of inclusion and social exclusion. That's what Professor Tiwari also attempted to explain. And indeed, social exclusion and marginalization appear to be interchangeable. Particularly, it is so visible in the Indian context. We talk about social exclusion and inclusion. I think social exclusion can also be marginalization can also be interchangeably used to mean social exclusion. So that's the one definition scholars have attempted to define marginalization. And second, for example, literally, it is also defined as the groups or individuals, they are denied access to important positions and symbols of economic, religious, or political power within society. So when you talk about marginalization or marginalized groups, normally this part has to be kept in mind when it say like they are, the access to the important positions or symbol like including economic, religious, or political power within society. And it is very aptly also one scholar said that a marginal group may actually constitute a numerical majority, for instance, as in South Africa, blacks in South Africa. But it should be distinguished from a minority group. Numerically, it may be small, but they will have access to political or economic power. And marginalization always does not mean minorities, sometimes. Similarly, there are a great number of definitions. Let me come to UNESCO. UNESCO also, in its one of the reports published in the year 2010, it attempted to define marginalization as a form of acute and persistent disadvantage rooted in underlying social inequalities. Examples of, that's what Professor Peacock said, that marginalization, like the major section of the population can be brought under marginalized group. For instance, according to UNESCO, examples of such most disadvantaged sections of society are girls and women, ethnic minorities, poor households, people living in informal settlements, individuals with disabilities, rural populations, nomadic populations, those affected by armed conflicts, those affected by HIV and AIDS, and street children and working children. So all of them can be considered as marginalized groups. So for which scholars have said that how to measure or understand marginalization. First of all, we need to understand or measure marginalization. And say like it is the first and foremost step in when you talk about access to justice, we need to understand or measure what is marginalization. For instance, we need to conduct household surveys and we need other kinds of data, and that would provide insights into the nature of marginalization. All of them cannot be treated as one homogeneous group, even among the marginalized. So we need to collect data from the ground level, and scholars have suggested that such disaggregated data can provide policymakers with the means to identify social groups and the areas or places characterized by high levels of deprivation. So that is the first exercise. I think I thought it's more appropriate. Keeping this in mind, I would like to just demonstrate two unique forms of victimization, which I feel that arise as a result of marginalization. For instance, victims of honor killing. And number two, I would also like, there is one, we had an act also. We had the British defined one group as criminal tribes. I would like just throw light on. There are some tribes, some sections of the population, even in the state of Tamil Nadu, how they are treated by the police. So that's going to be my second example. So first, when you talk about victims of honor killing. So killing it's a form of murder in the name of honor. That's what we call as honor killing. And here victims are harmed or killed by their own family members or acquaintances. It's a unique form of victimization, like female infanticide. So who will be the complainant? Whom do you consider as victim? As the moderator also raised the issue like primary victimization, secondary victimization, and tertiary victimization. Normally, like in any homicide case, the dependent can be considered as victim. But here, who are the dependents? Obviously, the family members, they themselves are the perpetrators of crime, point one. And when it comes to the official statistics, till 2013, there was no official statistics on honor killing. For that matter, even crime in India did not have any exclusive head, which can be called as honor killing. Now there's a separate head under the crime in India, which there's, for example, different forms of different motives for murder. How honor killing also becomes a motive of murder. Okay. When it comes to therefore, honor killing itself is a motive for murder. And statistics, just I would like to throw light on the statistics. And I have statistics of 2020. And over a period of, for example, 2014, 15, 16, 7 years, across India, we have 452 honor killings, excluding the UTs. If you take that also together, 461 such honor killing that took place. Some of the states like UP 162, Tamil Nadu only 5. And that's what, like when we compare these statistics with the statistics published by the NGOs, in Tamil Nadu they say over a period of 5 years there was 50 such honor, killing due to, the name of honor or honor killing. Whereas NCRB data shows that over a period of 7 years, only 5 such honor killing. So therefore, the reporting itself is the issue here. When you want to address the issue of honor killing, and which is the result of marginalization, obviously we need to look at the statistics. Therefore, NCRB also should be conscious enough to record this. And there are a number of issues, including how the police, for instance, some of the scholars have commented that sometimes police attempt to moderate talks between two families, and there have been many cases in which they had helped the separate couples. Instead of addressing the issue legally, police, they adopt different method to address that. So that has to be, for instance, in 2021, Punjab and Haryana High Court observed that was observation of the Punjab and Haryana High Court. The higher officials did not even know that the case fall in the category of honor killing. So that may be one of the categories of murder, but the higher officials should register that as honor killing. Otherwise,
Professor Srinivasan, may I just hold you there to ask you, do you believe whether, we have British crime survey, for instance, as a student, while I was at Oxford, I got to participate with one of the teams at Thames Valley, where you would have confidential subjective surveys. Now, considering the population and the nature of socio-demography in India, can we afford subjective surveys which may be confidential, which may again give us a reality check into what is being recorded and reported? Is it feasible?
Yeah, you are right. Actually, in fact, crime statistics in general is normally like we have an alternative system called victimization survey. So throughout the world, it has been in practice, but not in India. So normally when you take that, not 1/3, 3 times of the cases go unreported for any general crime for that matter. National crime victimization surveys are being conducted in several parts of the world. But in India, we don't have such exercise. That can be one such thing. And now NGOs, of course, NGOs also sometimes exaggerate. We cannot simply, straight away go by their statistics, but they provide whatever statistics they provide, they can supplement the official statistics. But official statistics, by and large, is not reflecting the reality. That is our experience, and for all forms of crimes, including honor killing. And we need to do such surveys, sir. That's what you are right, actually, you are right. And keeping that in mind, and next issue, for instance, it may be like a localized example, but I think that may be helpful for the participants to understand. The police atrocities against a scheduled caste, which is again a marginalized group. For example, there is one of the scheduled caste communities. The population in the state of Tamil Nadu is 10 lakhs. They are named Kuravan. And that is the sixth largest scheduled caste population in Tamil Nadu. During the British, what happened, like certain weak and vulnerable communities were literally termed as crime dynasty. They use the term crime dynasty to mean, in Tamil we call that as Kutta Parambari. That's they have the tradition. And the British passed an act called Criminal Tribes Act of 1871 and notified around 150 tribes in India as criminals, giving the police wide powers to arrest them and monitor their movements. So that was the case during British. Of course, that continued till 1952. In 1952, the Criminal Tribes Act was repealed across India, but these communities still continue to carry with them the stigma of criminality. For instance, in Tamil Nadu, of course, Government of India, it was a report on police atrocities against the Kuravan community published by the Government of India. There is a Scheduled Caste National Commission for Scheduled Caste. They published a report in which they stated that in one particular region, there are some cases, again, one particular person, 33 cases of property offense, theft, simply theft. And likewise, there are a number of cases being foisted on a particular group, thinking that they may indulge in these offenses. So that's a serious issue that has to be, when we talk about highly like marginalized community. And what we feel like is that they should be provided free legal aid through State Legal Service Authority to ensure the opportunities for securing justice to such marginalized or disadvantaged group. Free legal aid has to be widely, and we have to ensure that when you talk about access to justice. And for example, like people say, there are cases which are pending for 10, 15 years. So they presume to be innocent for 10, 15 years for simple a case of theft, Section 379 or such simple cases. So what we feel that to bring all cases foisted against such communities, marginalized communities from different districts or states, fast track mode in order to provide speedy justice. I mean, we have to find a fast track, establish fast track mode. That we should find all, it should be disposed of within a given time limit. So those kind of things have to be kept in mind when you talk about marginalized community. These are just examples, and I have not, because of the time constraint, I could not demonstrate the issue of marginalization with the help of several other things. That's what Prof. Peacock said, that everyone can be brought on marginalization and marginalized group. Thank you, moderator, for your
patience. Thank you, Professor Srinivasan. I think you rightly pointed out towards the end that speedy disposal and access to justice would not only render access to justice to the accused, but also foster a robust and predictable access to justice for the victim. It goes both ways. Thank you for the new perspective. Now, may I invite Justice Midha and allow participants to learn from his wide experience at the bar and bench and otherwise as an academician. Professor Justice Midha, over to you. Couldn't help but refer you to as Professor Midha as well. I've had the privilege of learning so much from him. Over to you, Justice Midha. Thank you.
Thank you, Mr. Sanjay Vashishtha. Professor Vajpayee, Honorable Vice Chancellor of the University, Professor Peacock, Professor Tiwari, Professor Srinivasan, and all the participants. First of all, I thank the University for giving me this opportunity to share my views on this platform. You see, access to justice to the victims of crime had been a very favorite subject with me from the time I joined the High Court. I still remember in my initial days when I presided over the criminal bench, I noticed that the victims are forgotten people in the criminal justice system. And the entire concentration of the criminal justice system at all levels, whether investigation or trial court or high court, is concentrated how to give justice to the accused. Nobody cares about the victim. Although Section 357 CRPC clearly provides that the victims are entitled to the compensation, and more importantly, I'll stress, such compensation which they would have been entitled to under civil law from the accused. Clear wordings are there. But I noticed that no court even calls the victim to find out what is the loss, what is the amount to which they are entitled in law, and they are not even called, and just a small token of amount is awarded without even looking at them. In the first case in 2010, there was a case of Satpal relating to motor accident victims, where I laid down the sentencing policy also, and I laid down the scheme how the victims of the road accidents, they have to be awarded the compensation. But compensation is one part. You see, victims are not even called to ask anything about the case. Let's assume the court is, so when again coming back to the position in 2009, 2010 when I presided over the criminal bench. So in every case I would call the victim. You see, many times when the bail applications are being heard or other things are being heard, so there are many questions posed by the accused to which the IO is not in a position to reply. And straight away we can ask from the victim what is the answer. If the victim is in front of us, we can ask him and have his view also. And then few cases I recollect. You see, in one of the cases, which was a case where there was a fight amongst the families of two brothers staying in the adjoining properties. So I said that please call the victim. So victim, when I called, so the victim had a serious head injury and he had undergone a surgery. Then I asked him how much money has been spent on the treatment. About 80,000 rupees had been spent by that time. And he said one more surgery has to be performed and this is the amount which is likely to be spent. So I suggested to the accused, are you willing to pay without prejudice? Ultimately, whatever happens to the case, whether you are convicted or not convicted, are you willing to pay ad hoc compensation to this person? This person has no money to even bear the medical expenses. Then I'll take up. And that person gracefully agreed. And later on, I noticed that the brothers also settled the main dispute also. Then there was one more matter where a person had more serious injuries and he had incurred about 10 lakh rupees by that time when the bail application was being heard. And there again, on the suggestion of the court, although there was initial very strong resistance, but finally the accused paid about, I think, 18 lakhs or 20 lakh rupees before the bail application was taken up for hearing. So coming back to the same position, we don't, when an offense is committed, at the investigation stage, the police record the statement of the victims. And then after the final report is filed in court and the cognizance is taken by the court, thereafter, till the stage of evidence, we don't call the victim as to what happened. Even if we frame a charge or even if we discharge, then also we normally don't call them. And then in cases where at the end when the accused is convicted and before sentencing, we don't call him. So in 2010 in the Satpal judgment for the first time, but though that case related to the motor accident victims, so sentencing policy was laid down and the framework was laid down. How the court, that in every case, the court after convicting will call the accused, will find out, there was a format prepared, as to how to ascertain the loss suffered by the victim, and there was also a format to find out what is the paying capacity of the accused, because law is very clear that we have to conduct a summary inquiry, and those guidelines were very strictly implemented in Delhi in all motor accident claim cases. But another opportunity came before me in November 2020, in which I was presiding over a full bench in a criminal matter, and I noticed that in all criminal cases, other than motor accident claims, there was no you can say practice, or there was no standard system followed to award compensation to the victim. Then I also noticed that one reason for that, and then I noticed that there are various Supreme Court judgments where the Supreme Court has time and again stressed on the need of strict implementation of the Section 357. And the Supreme Court noticed time and again that despite the directions the trial courts are not following. And finally, in the case of Ankush Shivaji Gaikwad, 2013, 6 SCC 770, the Supreme Court noted the prior judgments of Swaran Singh, Maru Ram, Hari Singh, Balraj, Baldev Singh, and Dilip. And court noticed that although we have time and again stressed that in every case the court has to apply 357, the Supreme Court in 2013 directed that if a magistrate does not follow 357, he has to give reasons. But I noticed that even after 2013, in 2020, which was almost 7 years, the courts were neither applying 357 nor even giving reasons. So even the Supreme Court directions were not being followed. So then the full bench thought it proper to lay down fresh guidelines, and the guidelines were, now these guidelines are, now I'm coming back to the topic, access to justice. Now victim is not even aware what is happening to the case, which court the case is pending, what is the loss, whether he is entitled to any claim or not. So therefore, duty has been casted on the court and the state legal service authority. And what is the duty and procedure laid down? That whenever the court will convict a accused, the court will straightaway not pronounce or take up the sentence. The court will direct the accused to file the affidavit of his assets in the proforma given as Annexure A to the judgment within 10 days. Now, within 10 days, the accused, this affidavit is necessary to find out what is the paying capacity of the accused. So, this affidavit, when is filed, then the court will send this affidavit to the State Legal Service Authority, and the State Legal Service Authority shall conduct a summary inquiry into the paying capacity of the accused. The court will also ascertain what is the loss suffered by the victims, and for that the court prepared the formats which are Annexure B, prepared a format of the victim impact report, and the State Legal Service Authority shall conduct a summary inquiry into the affidavit of assets filed by the accused as well as loss suffered by the victim, and the State Legal Service Authority shall file a victim impact report before the court. The format of this report is Annexure B and B1 to the judgment. So, now kindly see, first stage is that duty has been cast on the court itself to direct the accused to file the affidavit. Second, duty has been cast on the State Legal Service Authority that please conduct an inquiry and file a victim impact report. So, State Legal Service Authority will go to the victim and conduct the summary inquiry, fill up all the requirements of that format which is given, and ascertain what is the loss and submit a report. The matter will again come back to the court which had convicted the accused, and that court will consider the victim impact report, hear the parties, including the accused as well as the victims. So victims will have a right of audience. Now this is stage 3, when they are before the court, and the court will look into their loss, and then the court will award the compensation. If the accused has the paying capacity, then the compensation will be paid directly by the accused. But if the accused does not have the paying capacity, then the court will invoke section 357 capital A of CRPC to direct the state legal service authority to pay the compensation out of the victim compensation scheme. So therefore, is a stage prior to this judgment when the victim had no access to justice, and more particularly the marginalized people had no access. Even the other evil people also had no access. They were not called. There was no, even via media they can come to the court and say that please give. They are not even aware what is happening in the court. So that avenue has now opened. And now, in order to ensure, now the most important task was that this court was, the full court was concerned that the courts all over the country are disregarding 7 judgments of the Supreme Court, starting from Dilip and proceeding with Baldev, Balraj, Hari, Maru Ram, Swaran Singh, and Ankush Gaikwad, where despite the Supreme Court having said that henceforth if a magistrate does not invoke 357, he will give reasons, and the courts are not giving reasons. So the full bench of the High Court thought that now still this judgment may also not meet the same fate. So they directed all the criminal courts within the jurisdiction of Delhi High Court to file a monthly report before the Registrar General giving the implementation of 357 by them in the criminal cases. And if the Registrar General finds that any court is not complying with the directions, they will place it before the ACR committee of that particular judge. So with these directions coming forth, now the judges have also been made the stakeholder. So it is not that, although the law gives the immunity to the judge, but now in view of this, they will come back to their performance appraisal. So therefore, till July 21, when I demitted office, I noticed that the judges were very strictly complying with this report, which is coming strictly, and each and every case, the reports are being filed, compensation is being awarded, victim is being given access to justice. So therefore, this is one area in which, and I hope that in this judgment, the full bench also gave suggestion to the government to implement this to incorporate this in the rules, so that it can be implemented all over the country. So I think Professor Vajpayee was the member of that committee set up by the Home Ministry, where they were looking into to incorporate. And I think 10 days back, I also read that the Ministry of Home Affairs has called for suggestions for amendments in the criminal justice system to make it more perfect. So I think this is I hope the government will take note of this judgment in Karan's matter, as well as in that proclaimed offenders matter, which open a new avenue to the criminal justice system and access to justice, and also to marginalize the people. So, to my mind, this judgment gives a very new insight as to how to give access to justice to those victims who have suffered in the crime, victims of crime, and I hope in other areas also. To my mind, there's need in other areas also. As I said, this compensation stage will come at a very later stage when the person is convicted. If he is not convicted, if he is acquitted, and those things, that stage may not come. To my mind, the access to justice to the victim of the crime should be provided by the investigating agency, as well as by the court, as well as the legal service authority at every stage. And they should be involved in the criminal justice system, and more particularly the marginalized people. They should also be provided the access to justice. So I think the time today is this much only. So it may not be possible to go further, although this is a very good topic. and it requires a more lengthy discussion, but I look forward for some other opportunity to share more thoughts on this view. One more line I will add. In fact, I was discussing with Professor Vajpayee, although that is not criminal law, but again, partially criminal law. When the victim of a road accident, you see, in India, we have highest number of road accidents in the world. We have about 5 to 6 lakh accidents every year, and 1.5 lakh deaths every year, meaning thereby one accident every minute and one death after every about 3.7 to 4 minutes. So whenever there is a road accident, so one is the criminal law which sets into motion by the registration of FIR, and the other is the compensation law, where again the marginalized section of people had no access to justice. So now they were required to file a case. They had ignorant of law, and the access to justice was provided to them by the ambulance chasers, who again, which was not a healthy practice, but is still continuing in our country. So taking note again of the formula of access of justice, the Delhi High Court laid down the guidelines and framed a special scheme under which the access to justice will be provided to victims of road accident without need to file a case or to engage a lawyer also. Automatically, with the registration of FIR, the compensation law also sets into motion automatically, and the police has to file a detailed accident report with the claims tribunal within 90 days, which is treated as a claim petition, and the insurance company has to give response within 30 days, and the compensation in cases where the insurance is not disputed is to be given within 6 months of the accident, which again an example of access to justice. And how it is connected with criminal law, I'll just link it that also. And the criminal court, when the stage comes, when that driver is convicted, so criminal court will also call, apart from following the procedure which we have laid down in this Karan's matter, the criminal court in that road accident matter will also call for a report from MACT, Motor Accident Claims Tribunal, and find out how much compensation has been given to him in that. If no compensation has been received by a victim, or if the vehicle was not insured, then the criminal court will award the compensation. Whereas if it has already been awarded, then that amount will be adjusted, and the remaining compensation which the person is entitled is given. There also, it is an example of an access to justice, where the victim of a road accident is given access to justice without the need of filing a criminal case, civil case, or going to the tribunal, or to engage a lawyer. So the compensation law sets into motion, which is a very good example. And the good part is that in that case also, the High Court gave suggestion to the central government to incorporate these guidelines in the central motor vehicle rules. And the good news is that the central government incorporated the entire scheme framed by Delhi High Court in central motor vehicle rules, which have been notified on 25th February 2022, and they have come into force from 1st April, that is 3 days back, and that will apply. So that judgment, which had application only to Delhi High Court, is now the law, statutory law, to be applied all over the country, where the person will get the compensation without the need to file a case within a period of 6 months to 1 year, which otherwise the period was about 5 to 10 years. So from 5 to 10 years, we come back to 6 months to 1 year. No need to file a case, no need to engage a counsel, no need to prepare a matter. Everything goes into auto mode. So I think this is again an example of access to justice, and most of the victims are from the lowest strata of the society. So it is also the access to justice to the marginalized section of the society. So I think with this, I will close, and thank you very much for this session, and forward for Professor Vajpayee to arrange more such sessions on good topics in future. Thank you very much.
Sir, I'm really grateful for the insight, but I've been waiting to ask this question in person. Couldn't happen to see you the other day. Sir, wouldn't it be better if victim impact statement or victim personal statement would also be considered as an aggravating or mitigating factor in sentencing, and two, if the victim himself or herself had the opportunity to present the victim impact statement in person so as to make the process a little more inclusive for the victim. I understand that would be time consuming and may not be practically possible, but at least insofar as heinous crimes are concerned, if that could be considered.
Sanjay, you have asked a very, very good and pertinent question.
And sir, let me just say this. I also happen to have read an article by the learned Vice Chancellor, Professor Vajpayee, on Indian Express, which was corresponding on to the same notions. If I may just add to that.
You see, in the judgment of Satpal, which I gave in 2010 on victims' compensation to the victims of road accident, there I discussed the need of laying down a sentencing policy. And then relating to road accidents, I examined the law all over the world and framed the sentencing policy also. And also prepared a list of aggravating and mitigating circumstances. So the victim impact report here, even in this current matter, there are two separate formats, one for road accident victims and the other for other offences other than road accident victims. But the format of road accident victims of the road accident has got all those factors which are there, which are aggravating and which are mitigating circumstances. And I've laid down the sentencing policy. In the judgment of Satpal, I also discussed the need of having a sentencing policy. But unfortunately, we do not have a sentencing policy. I also had a desire to lay down the guidelines on sentencing policies on offences other than road accidents, but somehow I didn't get time to do research, complete research on this topic, and give a judgment on that point. Although I had that in my mind, but your question is very good. And if you see so many articles and authors who have strongly criticized that in our country we don't have a sentencing policy, whereas in all developing countries the sentencing policy is there. So meaning thereby, even after convicting a person, the court has a complete discretion to even award the almost negligible sentence. So, but this is a very good thing. I hope at some opportunity you take up this matter to the court and assist the court in framing some guidelines.
Thank you, sir. Thank you for
the assistance you require from me. I am always welcome it.
But we really look forward to that.
To my mind, and you can also look into Satpal's judgment and also current judgment. Wherefore, I have laid down the sentencing policy on road accident victims. Thank you.
Thank you, sir. Thank you. And since time is of the essence, there are many participants who have typed their questions in the chat box. If I may chronologically go through some of these questions. I think one of the questions at the outset is about Section 357 judgment being iterated by Justice Midha. Sir, I think you were referring to this landmark judgment on 357 guidelines. Could you please name that again?
This is judgment Karan versus
right.
State of NCT of Delhi. This is dated 27th November 2020. And I'll just give you the citation also in a minute.
Sir, I will type the citation on the chat box. I have it readily.
Give the citation. And there is a prior judgment of Satpal, which contains the, of course, this is more comprehensive, but Satpal is also a very good judgment on the which was in 2010, which contains the sentencing policy and other guidelines on road accident. But this judgment not takes care of that also. And this is a full bench judgment, whereas Satpal is a single bench judgment.
Thank you, sir. This is all noted. Now that there are not many questions in the chat box, may I open the floor to other participants? Either they can raise their hands or type their questions in the chat box, or simply unmute and ask their questions.
And one more thing I would like to add, Professor Vajpayee had given a great contribution in laying down the guidelines in this current matter also relating to victimology, as well as in the other matter relating to proclaimed offender, in which the guidelines were laid down. And I think Mr. Sanjay Vashishtha was also involved in this research project. But it was a very big project. Proclaimed offenders matter took me almost about, I think, 8 to 10 years to complete the research and lay down the guidelines. But I'm not sure. Professor Vajpayee, what is the status of the implementation of that committee? You're also part of the committee formulated by the High Court on proclaimed offenders.
Sir, actually, the MHA asked certain, things from High Court and even the state government on this particular issue. So MHA in turn contacted us because we were working on the MHA appointed Criminal Law Reform Committee. So we have actually incorporated, though this committee, the report is still not in the public domain. But I can say that we have significantly incorporated the great suggestions, because I was myself very convinced with the scheme that we have formulated and it was debated at length in the committee's meeting again and again, and I presented it very forcefully all through the meeting. And interestingly, sir, I must admit, the issue relating to proclaimed offenders was not at all on the card with the committee initially, because they didn't realize that this is a issue to be sort of looked at. But while working with you on this particular case, I got myself educated too much. And so I came back and I forcefully advocated that let us include this particular issue. It is very practical. And let us do so. The entire scheme based on your judgment, sir, we have formulated and we have incorporated in our draft report, and it is the part of it. So, sir, I'm hoping something really big to be there through that work that we have done.
Thank you.
Thank you, sir. Sir, there is a question by Nandini, and I think it is aimed towards Justice Midha. The question is regarding Section 357 and its application on cases, and how Section 357 promotes restorative justice.
You see, 357 says that the victims of the crime are entitled to such compensation which they are entitled to in civil law. So when I noticed that the courts are not awarding compensation, just give token compensation, somewhere 5,000, somewhere 50,000, somewhere 70,000. So I asked them that why don't you award appropriate compensation? So I noticed that the response was that, sir, how do we calculate? What is the formula? Now that formula of loss of life or injury to the body, that formula is not here in the criminal law. That principle we apply normally in law of torts or in motor accident compensation cases. So therefore, there was so much of a gap as to how to calculate. And secondly, there was also a gap and ignorance as to how to find out the paying capacity. So therefore, there was a need to find out, number one, paying capacity, and number two, the loss suffered, and then what are the parameters. So therefore, one contribution which the current judgment has done is that it has prepared a format of the affidavit to be filed by the accused about his assets, which will be verified by the service authority with the help of the police and STM. Similarly, the legal service authority will take information of which the format is there in victim impact report from the victim, and then on the basis of that, the service authority will conduct a preliminary inquiry, and the court will pass an appropriate order on it. So to my mind, the greatest thing which has been, and you can say greatest lacuna which was there earlier, the court was lacking the guidelines how to do. So this is a new, you can say, path which the judgment lays down. And now if you see the latest judgments of all the Delhi courts on criminal cases, you will find very nice implementation of this aspect. Although the judges are feeling burdened because earlier they used to give the conviction.
Mr. Prem Kumar Patel, please mute your mic. Sorry about the intervention, I think accidentally. Thank you. Please, sir, please continue.
You see, although the trial district court, session court judges are not very comfortable with this. Because earlier what they used to do, they will give a pass a conviction, then next day they will list for hearing on sentence, and then next day they will give the order on sentence. Now they have to conduct an inquiry. They have to wait for that 1 month period. So their work is increased, for which they get the same unit. But suddenly we have to follow the law as it is. Thank you.
Thank you, sir. Sir, I have a question for Professor Tiwari, Arvind Tiwari, if I'm unable to find him on my screen. But there is a lot of discourse on victims being informed about the stage of the process when it comes to a court matter or a criminal trial. Professor Tiwari, are you connected?
Yes, I'm here. Yeah, please.
All right.
Yeah.
So, in terms of victims being informed, and the jurisprudence surrounding victims being informed and keeping them well informed about the entire process, is that, in your opinion, feasible? And secondly, how can we foster victim participation other than victim participation through victim impact statements, personal statements, and otherwise? Are there other avenues which could be practically adopted at this juncture? Thank you.
Yeah. You know, this first thing is the information to the victims regarding his participation. That I feel that like although judgments are there, although legal framework is there, but still the victim, majority of the victims do not have that kind of information and knowledge yet. Number two, even if they have the knowledge, they do not have the bargaining power and the courage to challenge the system if that they are not being included or their participation is not being asked. Besides this victim impact statement, I feel that it is fine. That is also important. But the victim participation for example, if the public prosecutor is asking the victim, or the police is also patiently listening to the victim and asking, and also the judiciary, the judges, the magistrates and judges, as has been said earlier by you, like that if the court will also ask the victim, what do you want to say about impact on you? How do you feel that? What could be done with the offender? So, you know, this kind of, I'll tell you that when I was conducting a study for Bureau of Police Research, you know, many victims have said when we go to the police, whether they register our crime or not, if they will talk to us nicely, 50% satisfaction is there. So, you know, because the in the colonial mindset and the colonial kind of system is still which is prevailing in our country. And I'll say that though we are, you see, progressing a lot, but criminal justice system is still a little difficult domain, and slowly it is opening up. What I'll say that apart from the victim impact statement, if the victim is starting from, for example, from police, from prosecution, from judiciary, legal services authority, lawyers, if they are just approaching, talking to the victim, calling to the victim, listening to them, perhaps that would be having the great impact on the victim psyche and the victim satisfaction.
Thank you, sir. On a lighter note, I had a victim of crime approach me that, sir, I've been a victim of crime and now a victim of the system at large. Kindly assist me in withdrawing my matters and I'm good to go. So I think after our robust conference and the valuable insights by our expert panelists today, and you know, remarks made by other participants and the questions, this has been, in fact, a very, very fruitful session. I understand that time is again of the essence, and we are towards the end of our time for today. But let me once again take this privilege and an opportunity to thank all our speakers and thank them from the bottom of our heart and on behalf of Vashishtha International.
If I may just interrupt, I'm very sorry for interrupting. I think Professor Robert Peacock had raised his hand.
Oh, I'm so sorry. I'm on a system where I'm unable to foresee. Please, Professor Peacock, please go ahead. Please, I'm sorry.
Thank you. Thank you so much for the very quick opportunity. Just to share with you some of our experiences, we've been quite successful to implement restorative justice processes throughout our entire criminal justice system, starting with the police, the courts, and corrections. So I think there is definitely some value and benefit to learn there. But in terms of what the victim, the main role player, requires, I would definitely recommend, and I'm sure that this must have been on the agenda before as well, that you conduct victim surveys, because there are often these misperceptions that victims want retribution, and that principle of proportionality can be dealt with in other ways. So just that for a few remarks. And just finally, congratulations for this judgment. I think this is wonderful. It paves the way to do great empowerment. Just one small question in terms of the marginalized groups, and our honorable judge referred to them as well, other than the road accident and safety victims. How are they brought into the system? Because usually they will be very fearful of the police, because being treated like suspects in the first instance. So that's just a very quick question. Thank you so much.
Justice Midha, I think that question is addressed to you, and if I may request you to kindly unmute.
You see, when we examined this issue of victim compensation, then Professor Vajpayee was assisting me, and there were other amicus also, and they had examined the law all over the world, and then they had given the suggestions, which we have incorporated in this scheme. And to my mind, this is a very fine system, and although I'm very happy to note from Professor Peacock that they are already giving the compensation to the victims in all cases, but so far as our country is concerned, it's just a recent phenomena, and that also this judgment for the time being is being implemented only so far as Delhi is concerned, and only if it is incorporated in the rules or CRPC, for which the suggestions have already been given, and we hope that it will be incorporated like the central motor vehicle rules. Then it will have already an implementation. But otherwise, for the time being, this victim compensation, which is happening in Delhi, is not even happening outside Delhi. So this is a very recent phenomena. We are very young in this, you can say. I'm very happy to note that in your country, you are able to do it. You are doing it very successfully for a very long time. Very happy to note. But here we were, despite the, you see, in CRPC section 357 being there from such a long time, and then Supreme Court 8 times saying, please do it, please do it. Then finally saying, if you don't do it, then give reasons, then also not being implemented. And then even after 2010, Satpal judgment, they are not doing it. But now once we put them into stake that they have to send a monthly report that the things have started happening. But I'm quite hopeful the things will improve. But I must compliment Professor Peacock to tell us that they are successfully doing it. But we hope to grow further, and if this is implemented, I think it will be a good thing. But at the moment, we are not able to give access to justice to everybody.
Thank you, sir.
Thank you.
Mr. Kaushik, are there any other participants who have raised their hands? I'm unable to. I've checked and confirmed though. Please, Bajpayee sir, of course. Sir, you're on mute. May I request you to kindly unmute?
So thank you, Sanjay, for this. I'll just take 1 minute because I couldn't resist making finishing remarks for this wonderful, very enlightening discussion. But for the presence of Honorable Justice Midha and Robert Peacock, Srinivasan, and my dear friend Professor Arvind Tiwari, you have brought a very important issue to the central stage, where we are discussing marginalization and access to justice in order to empower the victim. And we have one very live and great example coming from Justice Midha, where we have tried to, convert the victimological formulations into a legal reality. This is something very important, and in a country like India, this route is often very successful, because sometimes the legislative development takes a long time, and it is very hard to come by. But through some time, whatever victim jurisprudence has evolved in this country, it is mainly through the activism of the courts. And this is one example where we have tried to brought in the victim impact statement and victim impact report as a reality. So I believe that if we want justiciable rights and justiciable victimological solutions in the realm of Indian victimological debates and concerns of crime victim, we need to look at the judiciary, and we need to sort of bring more and more legal activism in order to get certain order passed from the courts, so that they become landmark and binding on all the state government actors or the central government actors and all others. So that is one route that we are, this is my learning from an important takeaway from my participation too. Because victim advocacy, which is simply concentrated at the community level without legal footing, continues to provide a lot of solace and protection at initial level. But if you want the rights to become justiciable, if we want solution to become justiciable, we need to provide them a legal form or legal reality. So therefore, I feel that this is very, very important. And in case of access to justice and related deprivations, because the World Justice Report, which is a very massive project being conducted by a lot of people in the US, they are saying some 35 to 40% people in the globe are still living out of the protection of the law. This is a chilling statistics telling a serious comment upon the efficacy and capacity of the criminal justice system. So I am thinking that non-access is actually a form of deprivation. And when we talk about victimization, we consider victimization is simply a state of affairs that may be associated with the accused or the victim or anybody. Victimization is victimization. So ensuring the access is something very, very important. And for that, I think a serious movement for victim advocacy is need to be launched. That is what we are doing in law school. We are teaching the student about victim advocacy, so community level advocacy and the court level advocacy. And probably then you can bring these, victim rights as reality. So I feel that today's discussion was immensely benefited by the gracious presence of Honorable Justice Midha, and he has also mentioned that I had, because I have been working in victimology for last many years, but my participation in these two very important cases where he has appointed me amicus, that has changed my perspective towards the possible solutions, which can go a very long way for the victim empowerment. So thank you so much, Justice Midha, for your kind presence. Yes, you wanted to say something.
No, I would like to request Mr. Sanjay Vashishtha to please collect the entire, that successful implementation law as mentioned by Professor Peacock, and then see that if we can further add to our scheme, yes, then since the central government is now considering the scheme, and if there's something further better we can find out from the law which is there as mentioned by Professor Peacock, we should incorporate that also in our suggestions which we'll give to the Home Ministry.
Yes, sure.
To frame the law at a national level, because the judgment is still at the Delhi level only.
Yes.
The government is framing, since they are very successfully doing it, we should also borrow, and whatever we can get assistance from Professor Peacock.
Yes, and so
that is the purpose of these conferences, no? That we share knowledge, and whatever we gain better, we also incorporate that in our future implementation and the future laws.
Very right.
And
So,
from
sir-
other speakers also, Mr. Vashishtha can collect their views also.
Yes.
And
Sure.
because still there is time for giving suggestions, it is only last week that central government is invited. I saw in newspaper that central government has invited Ministry of Home Affairs that they are amending the Code of Criminal Procedure, and they have invited suggestions, and they have also framed a committee of NUL, I think NLU Delhi.
Yes.
That committee also they have framed. So I don't know whether the suggestions it will better to send through the committee or directly we can send that Professor Vajpayee will examine. But certainly we can take the further inputs from all the speakers today and to be incorporated. And Mr. Vashishtha, please also circulate the judgment and with the speakers so that they can
I will
give their suggestions further to improve the law.
most certainly.
Thank you.
Over to the coordinators now.
Thank you, sir, and thank you for the wonderful end to the conference. And may I once again thank all the speakers and especially Professor Vajpayee for his inputs and suggestions towards the end. As rightly pointed out, I will make some endeavors to collect the data and revert back as expeditiously as possible. And may I wish all of you a pleasant day ahead. Thank you, participants. Thank you for your time and presence. Thank you so much. Thank you, everyone.
Thanks.
Okay. Thank you so much, Mr. Vashishtha, for this wonderful moderation that you have done for the session. Your work has been impeccable. We really appreciate you. And it's always a pleasure having you over for our events. Right. So, on behalf of the Center for Criminology, Criminal Justice and Victimology, I thank all the panelists for this session. Professor Robert Peacock, Professor Tiwari, Professor Srinivasan, Honorable Justice Midha. I thank you for sparing your time and your efforts to, and as well as your thoughts with us today. It has been a very fruitful first day with respect to this first International Victimology Colloquium, and we have had very enriching discussions on very pertinent topics such as reparation for victims of cyber crimes, community-based restorative justice, and this final session on marginalization and access to justice. Tomorrow, we have equally important topics lined up for panel discussions as well. We'll have discussions on judicial responses and victimhood, empowering victims against secondary victimization, and victim empowerment and transnational conflicts. So tomorrow's sessions will be starting at 10 a.m. and I request you all to join us for the same as well. So with your permission, may I now close the session?
Yes, sure.
Thank you. Thank you, everyone.
Thank you.